Welcome to the Beneficiary's Corner. This course will discuss your rights and options in dealing with no contest clauses. Let's get started with the facts. These are the beginning ground rules for California no contest clauses. Under current law, California no contest clauses only apply to direct contests brought without probable cause, to a pleading to challenge the transfer of property, and to the filing of a creditor's claim. Let's consider a hypothetical situation to demonstrate the problems that arise and the options you have when confronted with the California no contest clause. After the hypothetical, we will discuss the application of no contest clauses in more detail. On August 24, 2015, Nancy hired a lawyer and created a revocable trust that left her estate equally to her three children, Robert, Richard, and Lisa. The following year, Nancy started showing signs of dementia. She began having trouble driving and could not handle her financial affairs. Her daughter Lisa started helping Nancy to pay her bills and go to doctor's appointments. Around the same time, Robert moved into Nancy's home because he had lost his job. Lisa noticed that cash was being withdrawn from Nancy's account, and she asked Robert about it. Robert became very defensive, denied taking any cash, and refused to discuss it further. In May 2016, Robert told Lisa she was no longer welcome in their mother's home. Robert stopped Lisa from seeing Mom and even talking to Mom on the phone. Robert then took over all finances for Nancy and took Nancy to all doctor's appointments. On January 5th, 2017, Nancy died. After Nancy's death, Richard and Lisa both received a letter from a lawyer for Robert, along with a copy of Nancy's trust documents. Among the trust documents was a trust amendment that changed the trust distribution so that Richard and Lisa each received a specific gift of $50,000 and Robert received the rest of Nancy's estate. Nancy's gross estate was worth $2 million at the time of her death. The trust amendment was dated and signed on September 14, 2016. The amendment was drafted by Robert using an online trust creation service. Robert then had his neighbor, who is a notary public, notarize the trust document. After Nancy's death, Robert hired a lawyer to ensure that the trust amendment would be administered for his benefit. Both the trust and the trust amendment have a no contest clause that says if anyone directly contests the documents, then that person will lose their gift under the trust. Richard and Nancy would like to contest the trust document based on undue influence and lack of capacity, but they're concerned that if they do so and lose, they will each lose their specific gift of $50,000. What can they do to fight for their inheritance? Here are the options. Option number 1, do nothing. Accept the fact that they're only going to receive $50,000 each and go their separate ways. Option number 2, file a trust contest alleging undue influence. File a petition with the California Probate Court alleging that the trust amendment is invalid due to undue influence. Option number 3, file a trust contest alleging lack of capacity. File a petition with the California Probate Court alleging that the trust amendment is invalid due to lack of capacity. Option number 4, file a financial elder abuse lawsuit. File a civil lawsuit in California Superior Court claiming that Robert engaged in financial elder abuse in creating the trust amendment. Option number 5, negotiate a settlement without filing a lawsuit. Contact Robert and attempt to negotiate a settlement prior to filing any lawsuit in court.